Welcome to the fourth in a series of NJAPM CLE webinars. Today's program is titled Challenging the Ethics of Mediator Neutrality, and it's presented by Dr. Rachael Field. Rachael Field is a professor in the Bond Law School in Australia and co-director of the Bond Dispute Resolution Center and Bond's Center for Professional Legal Education. Her areas of teaching and research expertise include dispute resolution, family law, and domestic violence. Rachael is an accredited mediator under the National Mediator Accreditation System in Australia and an accredited family dispute resolution practitioner. She is also an honorary visiting professor at the University of Portsmouth and an academic bencher of the Inner Temple in London. Before we start, there will be two attendance codes read during the program. Do not put the attendance codes in chat. Also, we will have a recording of this program on our YouTube channel within a couple of weeks. So if you've missed a code, please go get it there. If you want to ask a question, you can either put the question in the Q&A or raise your hand at the appropriate part of the program. Please do not use the chat for questions because then we have to look all over the place for questions. So with that introduction, Rachael, oh, and let me also mention, it is 3 a.m. in Australia. So I especially want to thank Rachael for doing this because I would never get up that early. But so Rachael, thank you very much for doing it. And it's now yours.
Thank you, Carl. Thanks so much, everybody. And I just really want to thank Carl for inviting me to have this opportunity to speak with the New Jersey Mediators. It's a privilege, and I don't mind getting up at 3 a.m. because otherwise I wouldn't be able to be doing this and having this conversation. So in Australia, we have a tradition where we acknowledge countries. So if you could bear with me just to acknowledge the lands on which I'm coming to you from today, which is the lands of the Kombumerri Saltwater people of the Yugambeh language group. And we pay our respects to elders past, present and emerging. And I'd like to acknowledge the original custodians of the lands on which you are joining us from in New Jersey. So thanks so much, Carl. What we were hoping for today is to just have a big conversation about some potentially difficult ethical issues, and to which there is no right or wrong answer. There are just different perspectives. So I'm really offering a perspective from the Australian context, and I'll just share my screen with everybody. Whoops. So that we've got a little bit of a framework for what we're talking about today, but I don't want to be too wedded to these slides. I'd like them just to be a resource for everybody. And I'd really like to sort of move through them and then get to our discussions, because I think that's where the richness of the session will really come. So just very quickly, I wanted to give a little potted history of the practice of mediation in Australia and our context currently in terms of ethical issues. So essentially in Australia, we followed really much of what happened in the US in terms of the development of mediation out of the Pound Conference. And it was in the 80s and, well, the 80s mainly, that community mediation really, took off at a ground level. And there were some elements of government that supported that. So there was community justice centres that were introduced in government in New South Wales, one of our states, and also Queensland. And that then started really a movement that brought government on board. And we now have a situation where the practice of processes other than litigation, so mediation, and we generally sort of define mediation in terms of the facilitative model of mediation, is now sort of integral to every aspect of the civil justice system. So for example, in family law contexts, it's now a part of the Family Law Act of Australia that parties are unable to file in the family court if they haven't had a go at resolving matters through a mediation-like process. So the pre-action attempts at resolving matters has become sort of embedded across the civil justice system in a whole range of contexts, and it's now expected that people will take genuine steps. So it's not, you know, in a sense, my co-author Lawrence Bull and I have a book where we just drop the word alternative altogether, because dispute resolution and processes like mediation is so much a part of what happens in Australia, in the legal system, but also, you know, outside of it. So in that context, then, we've got a national mediator accreditation system. It's a voluntary accreditation system, and it's the system provides the practice standards for mediators who are accredited under it. But we aren't regulated with any other sort of form of professional regulation. So it's just a voluntary system. And if you are accredited under that system, as Carl acknowledged that I am accredited under that system, then I am holding out that I will adhere to the practice standards. And one of the practice standards is that the mediator will be impartial. Not that that's clearly defined at all. But that's where we'd like to sort of focus our discussions today, is on that issue of mediator impartiality, and what does it mean, and how does it work, and where are the boundaries, or the where are the hotspots in terms of impartiality and how it works. So in getting through the slides, I just wanted to give you a bit of an introduction of some of the thinking that my colleague, Professor John Crowe, and I have been doing, and just see if we can spark some fresh ideas about things. I think, in a sense, from talking with Carl previously, that that some of what we're saying is where you may well be at in your practice. It may be just affirming what you already do. So I think it's important for me to say that these ideas that I'm talking about here for Australian mediators are quite challenging. So in Australia, we haven't, I don't think that we're really honest about the nature of our practice. It's confidential, it's private, and whilst we have the practice standards under the NMAS, mediators will say that they struggle with the reality of achieving impartiality. And that sometimes they feel that they are doing things that may not necessarily adhere to the definition of impartiality, and we might define it differently. So what they're doing in practice is not necessarily sitting comfortably with the theory. And I guess, John, and my key message is that for a profession that is now sort of hitting its stride in terms of being so much a part of the Australian legal system, and in fact globally, that we can't have an ethical paradigm that doesn't match up with what we're doing in practice. That the two have to speak to each other, otherwise the ethical paradigm is not authentic and doesn't have integrity. So we'd love to focus on some collegial discussions today around this issue, and just toss this issue around. That would be fun. So what we're talking about here is coming from this book that John and I wrote, Mediation Ethics from Theory to Practice, and it was really Bernie Meyer's work from 2004 about neutrality was an inspiration. And I think the thing is that we don't, whilst we're always quite often saying that the concepts of neutrality and impartiality are flawed, we haven't really moved the mediation profession globally on from the use of those words. So John and I are suggesting that we really, now is a good time to do that. But I think it's important that I say that what we're not challenging is the idea of fairness or even-handedness or appropriate treatment of the parties. What we're challenging is the notion of whether impartiality always results in fairness, and if it doesn't, then what kind of paradigm do we need to give that ethical framework to our practice as mediators. So the traditional ethic for mediation is based on mediator neutrality, leading to party self-determination, or mediator impartiality. In Australia, we don't use the word neutrality now so much. The only word that you'll find, and I think it's the same in your code of conduct, the word that you'll find is impartiality, not neutrality. But the sense of the word is still consistent in whether you say impartiality or neutrality. And if you look in dictionary definitions, one will often be defined in relation to the other. So I think the semantics of distinguishing neutrality and impartiality is problematic, because generally the parties, the people on the street, are not going to know what that distinction means. But generally that's taken as resulting in party self-determination. And I think it's the same in Australian mediation and mediation in the US, that a fundamental goal of mediation is that the parties will achieve a level of self-determination. That's really what makes mediation special. It allows the parties to negotiate a mutually acceptable outcome. And that's our role as a mediator, is to facilitate a process that helps them to do that. So the bottom line, I think, in terms of defining mediation, is that a mediator won't make a decision for the parties. That's generally how facilitative mediation is defined. And there's a lot of really excellent literature from the US around whether evaluative mediation, for example, is an oxymoron, because it goes beyond beyond that, in terms of mediation being a process focused on party self-determination. So that's our traditional ethic, and there are lots of challenges from it. So one of the challenges is that mediators are human, so neutrality isn't really possible. Another is that mediators are really, in reality, quite powerful in the mediation room, and they do, even in terms of controlling the process, can have significant influence on what happens in the mediation room. Another challenging concept is that neutrality or impartiality may in fact undermine party self-determination. There may be levels of activity or intervention that a mediator needs to do that wouldn't sit well with the definition of neutrality, but would actually be what's required to support the self-determination of the parties. And another challenging thought is that maybe the parties don't want impartiality or neutrality in the sense that a mediator may feel they are obliged to perform it. They may be happy to accept a mediator's intervention, their expertise or their judgment. Maybe that is what they're paying for. So my colleague Lawrence Bull, as I said, has made a distinction between impartiality and neutrality, saying mediators can't be neutral, but they can be impartial. But as I said, that doesn't work for me, in that I don't think it's where the people who are using our services come from in terms of making these nice distinctions semantically. So I don't think that works. And what John and I are proposing in our book, rather, is that we shift the focus of an ethical paradigm for our practice as mediators, not on that we must be impartial and neutral, but that rather we must do what is required to support self-determination with the parties. And that's because self-determination is what's distinctive about mediation, and it's why people come to mediation, is to achieve this input into the resolution of their own dispute, rather than having a third party impose a decision on them. Self-determination is associated also with the legitimacy of mediation. It's how the process sits well with democratic values such as consent and autonomy and privacy and dignity. It's consistent with relational values. So it really is at the heart of what mediation represents. So the framework that we offer in the book is that neutrality and impartiality are not jettisoned. Rather, we value them as tools that mediators would obviously use to achieve self-determined outcomes. But in some circumstances, self-determination might require a departure from what might traditionally have been considered a neutral stance. And the focus rather should be on what is necessary in a given context to support the self-determination of the parties. So the framework that we offer includes these elements. It includes the informed consent, which is a really important part of self-determination, and that can be a difficult thing to achieve. The parties need to be able to take an informed consent approach to whatever outcome results. It requires a level of professionalism on the part of mediators in terms of how the fiduciary-like obligation to parties is played out, so that links back to the standards and the practice standards, but and also to levels of competence. So we must have the necessary competence to be able to work with an ethical framework like this. It also requires contextual judgment. So that requires mediators adopting reflexive and collaborative outlooks. And there's a whole theory of ethics that is known as contextual ethics. And so we're saying that that's the kind of ethical judgment that mediators need to have, not a rule-based judgment where you have a rule that says you must be impartial. We don't necessarily always know what that means. Rather, using a contextual ethic, we're saying in the context of a given matter, a mediator needs to make a judgment about how they are going to best support party self-determination. And then the final element of the framework is relationality. So recognizing that that is at the core of the mediation process, and that the people and their communication with each other is critical to achieving the right ethical outcomes. So wanting to move to some discussion and a debate or just further elaboration on these points, but here is some further reading and some things that John and I have written together and also separately around this issue. So I commend those things to you, and I'll stop sharing my screen.
Thank you, Rachel. I was pleased to see that you have sort of eliminated the distinction between neutrality and impartiality, at least as far as practicality. So, for example, I know one of the people on the call, our Zoom meeting today, is Ken Newman, who teaches a lot, and he and I have taught in the 40-hour course for a long time. And every year he would tell me the difference between neutrality and impartiality. And I got to tell you, it just never stuck with me. I could not, in a meaningful way over any period of time, make that distinction. And I tried it out on my wife, who's a psychologist. What's the distinction between these two? And really, she heard what I'm saying, but she couldn't really distinguish the two. So yeah. I totally agree in practical terms.
Yeah, it's interesting because Lawrence Bull, who makes this distinction very firmly, and he has really strongly influenced the National Mediator Accreditation system, and the fact that it refers only to impartiality is his influence in saying we can be impartial, but we can't be neutral. And he is a colleague of mine at Bond University, Bond Law School. In fact, he started the centre that I co-direct now back in 1989. So we've had some pretty tense moments over coffee. Because we just have such different views on this. But I agree with you, Carla. It doesn't have any meaning in terms of the people who are coming to use our services. And we just don't have time in our mediators opening to go into how we might be impartial but not neutral, and what that might actually mean for the ethics of what we're practicing. So yeah, I think we've got to find some better way than trying to rely on semantic distinctions.
You mentioned that impartiality seems to be the word that gets incorporated now into standards of conduct. Let me point out, though, that the court's rules still use the word neutrality with respect to what a mediator is supposed to be, and what it's Rule 140 in New Jersey. And it says a facilitative process, which includes mediation, is a process in which a neutral third party facilitates communications between the parties in an effort to promote settlement without imposition of the facilitator's own judgment regarding the issue in a dispute. Now, what's amazing about this is, at least on the divorce side of court-connected cases, everyone is extremely directive. And in fact, former judges are hired because they will tell people exactly what will happen, in their opinion, if they go to court. So it is the least facilitative, the least directive place you can go. And even though people have tried to get the court to change this, saying it's not a facilitative process, et cetera, it stays there. But also, there don't seem to be definitions of impartiality, at least in art. And why is that? If you're going to have a standard, why don't people at least define it?
Exactly. I agree. And I think, it's the thing that bothers me about it is that with the whole ethical framework of our practice is then premised on this flimsy notion about which we don't even have a proper definition, and it isn't actually necessarily truly a part of our real practice. And yet, it's at the core of how we say we are protecting party self-determination. But, there's so much literature on this point, particularly from the US. This has been debated for decades, and we just seem to go round in circles. And I think that that's just not satisfactory in terms of the modern, well, we wouldn't even say in Australia, we haven't even yet really gotten to the point of saying that mediation is a profession in its own right. It's sort of an adjunct part of a profession of other professions. So, for example, lawyering or psychology or social work or therapeutic practice. It's not necessarily regarded as a profession in its own right. And I think we need to start thinking of it as such, because it's so integral to dispute resolution at large and in the civil justice system as well. But when you're talking about different approaches, Carl, I mean, that if lawyers are practicing mediation in Australia, then often they are practicing, if it's a retired judge or a barrister of standing, they would be also very directive, to the point where it was mooted fairly recently that there should be a separate statement of practice standards for lawyer mediators, distinct from the one under the National Mediator Accreditation system. That didn't actually ever happen. But it was suggested.
Good break. Let me read the first attendance code. The first code is 1399 1399. So let's go back to, if people aren't paying any attention to these distinctions, if they're not paying attention practically to anything, what is this discussion about? And if there's no place to sort of penalize people, if they belong to a voluntary association, I guess they could get thrown out. But what's the practical consequence of all of this? Or is it just something that we like to talk about?
Yeah, I think the practical consequence is that we want to have efficacy in our practice. We don't want to be doing harm, and we want to be, I think every mediator that I know comes from a really warm place in their heart that they actually really want to help people. And that's why they're drawn to the process, because it has that relational aspect to it. It has that respect for the autonomy of the parties, their own expertise in their own dispute. And it just acknowledges that at this particular juncture, the parties are lacking a capacity to work things out on their own, and they need the support of a process that has a structure to it, and they need the support of a good communicator in the mediator that is going to respectfully help them have a conversation. So I think, that's a very special thing that we have with our process, but it occurs in contexts that are confidential and private, and there's nobody really making sure that mediators are practicing the process according to the standards. At least in Australia, nobody is checking up on that. And it's only when the parties really aren't happy with the service that they've received and they put in a complaint to the service provider that, anything would come to light about the standard of practice. But I think more and more as mediation is a part of how things are done and how disputes in legal and other contexts are sorted out, we really need to be able to assure people that we are ethical practitioners and that we will be adhering to some principles of practice. And for John and myself, in terms of the book, that fundamental principle has to be the party's self-determination, because that's what's special for us about mediation. And it's what you can't get if you go to litigation. You're not really getting party self-determination, you're getting the decision of a person who doesn't know you, doesn't know your circumstances terribly well, has only had limited information put to them. You know, so we want efficacy of practice. And I think that what we're saying is that mediation doesn't have to now be trying to convince people that it is something that it's not. So in one of our articles, we wrote about the legitimacy of mediation quite a while ago, which was saying that, you know, some of the rhetoric around the ethics of mediation has to do with impartiality, because that was replicating what litigation offered. So the judge would be impartial, hence a mediator has to be impartial to have efficacy. But we don't need to use those words. We don't need to try and that's a whole part of mediation, moving away from being the alternative to litigation and being a process that has value and standing in its own right.
So in the United States, or myself, I often talk about, you know, I think the process ought to be fair, impartial, whatever terms you want to use, but I'm less concerned about the outcome being fair. And, you know, so there's a California rule that talks in that sense, the mediator's obligation to make sure the process is fair, but has no obligation that the parties reach a fair result. You know, that's my view of it, because I view fairness as, you know, everyone's got a sense of fairness, their own sense. The parties have theirs, and it's really difficult to deal with that if everyone has a different sense of fairness. I think you feel differently about that, don't you?
I think I do. I just, in terms of some of the mediations that I've been involved with, and I've been adhering with my so I only ever co-mediate, which is a luxury, because I always learn so much from my co-mediator, and it's the same person. So my colleague, Associate Professor Libby Taylor, and I co-mediate. We co-mediate in our clinic at Bond University, which is a teaching clinic, but often Libby and I are just doing the mediations ourselves as two of us. So there have been occasions where I have felt that I needed to intervene, maybe in a private session, and maybe challenge a party, or maybe set their perspective on their understanding of their legal position straight or something. And I just haven't been able to do that under the model that Libby and I practice. And we've had discussions about how that then concerns us, that the substantive outcome then is going to be unfair. And our approach has been to say to the parties, you need to go away and get independent legal advice on this. But of course, the parties go away and get the advice that they want to hear, in a sense. They give the lawyer the information that will get them the advice that they want to hear. And then they bring that back. Or they get the advice they don't want to hear, but they still bring back what they want to hear to the mediation room. A colleague of mine, Susan Douglas, did a PhD thesis where she was interviewing a number of mediators, and they were all mediators who were ostensibly practicing the facilitative model. And a really significant number of them struggled with whether they were presiding over what really ended up being an unfair process, because the outcome was unfair because they couldn't intervene more. And there were perhaps significant power imbalances between the parties. And so as they stood back and just, you know, let the outcome be whatever it would be, and as long as they were facilitating a fair process, so practicing the process fairly, but they knew that the outcome would be substantively unfair in the end. And they struggled with this in terms of their feeling that that in fact was unethical, to preside over a process that would result in what would be unfair outcomes. So I think that is where I come from as well. Of course, it comes back to things like competence. So we can't just allow mediators to be intervening and giving advice or pressuring parties to come to a certain point of view if they don't have the necessary expertise and competence, which is why that is an element of the professionalism component, is a part of the paradigm that John and I are suggesting. But I think it just has that really difficult. I've found it very difficult to reconcile, and I think Libby and I are moving towards perhaps a slightly different approach in our practice, which is to be a more interventionist, based on our expertise, of course, because we both have family law backgrounds, so we have some expertise to draw on there.
Okay, so in New Jersey, and I'm going to state what I believe the law is, which is that anybody can teach the law. You know, you don't have to be a lawyer in New Jersey or practically anywhere in the country to teach the law. You can explain cases, etc. You can do all of that if you're not a lawyer. What you can't do is provide legal advice. And we commonly say that you take the general law, you apply it to the specific fact situation, and then that becomes legal advice. So that's the distinction we commonly make. Some lawyer is going to get angry with me, I'm sure, but that's what happens. So you either don't make that distinction, or you're not comfortable with saying, okay, I'm going to explain all the law to you, or I'm going to explain the case. Is that correct?
Yeah, so I guess in Australia, we do try and make that distinction as well between giving information, which would be regarded as, even within the traditional paradigm of impartiality, would be regarded as okay, and giving advice. And I think that the lines are very blurry there in terms of what constitutes information and advice. It sounds like you've got a much clearer sense of that in the United States than we perhaps have here. And I guess I'm wondering why that might be. And one of the thoughts that came to mind is that in our family law context, the law itself just isn't really necessarily something that you can usefully describe to a person and have that be helpful. It needs interpretation. It needs application to a person's situation for it to be meaningful. So our entire Family Law Act, basically the entire Family Law Act has provisions in it which you could describe to the parties. You could say, well, this is what it says about the primary principles of parenting. This is what it says about how you determine what the best interests of the children are. You look at all these different categories. But in order to really apply that, or for a party to be able to make sense of it, it needs an element of interpretation of it. So there's not, I do struggle with that distinction between information and advice. And I guess the ethical approach that we're suggesting in the book is that as long as you've got competence, and as long as you've got the knowledge and the expertise, which doesn't mean that you have to be a lawyer necessarily, but you need to have the experience and expertise, then you are providing whatever is necessary to support party self-determination of both parties. And I think that that's the difficulty, isn't it? That in mediation, we don't want just one party to achieve self-determination. We need for both of the parties to achieve self-determination. It's a relational thing, and they need to be able to walk away both with a sense of that mutual achievement of an outcome that is meeting their needs and interests. So giving information and advice is it's a complex distinction, but I think sometimes it's necessary for us to give more. In Australia, people are probably giving more advice than they are willing to recognise, I think is what I'm saying. So we need an ethical approach or an ethical framework that supports that, rather than pretending that that's not happening.
Right. There was a study done in New Jersey by Ken Kressel. I think he taught at Rutgers. And he evaluated a number of professional mediators who were in role play. And almost nobody classified themselves correctly as facilitative, et cetera. In fact, almost no one was facilitative. Almost everyone blended something facilitative, evaluative, maybe some directive, I mean, all kinds of things. So there's not a lot of self-awareness of what we're actually doing. Not that that's necessarily wrong, because I think most people do blend a lot of things.
I think that's the reality. But I also think, though, Carl, and I wonder, if your constituents would agree, that when people are coming to mediation, they are often quite vulnerable themselves. Like, they're not at the best point in their life in terms of being creative thinkers or, wonderful problem solvers for what might be really challenging conflict or disputes. And so the traditional paradigm of mediation, in terms of how a mediator sits back, be impartial, just implements a process, and the parties will achieve self-determination. For me, I think that's asking a lot of people who are not at their best. So they're coming to us for our expertise and our assistance, not just to be left on their own to work it out on their own kind of thing. And I know that, in implementing a process, we're not necessarily leaving them on their own. But I think maybe they need a level of support. And I think we were talking about this earlier, weren't we, Carl, about, having a bank of previous matters where you could derive some suggestions or options for, what people in previous situations have done. So in Australia currently, that would be considered as perhaps too interventionist or too active to access a bank like that or to make suggestions in that way. Theoretically, it would be considered not the right thing to do if a mediator is to say that they are impartial, because how can you be sure that you're not drawing from that bank in a biased way in terms of where you want to see the parties going with an outcome? What's the filter?
I guess there's no guarantee, but a mediator could try the best that he or she could to be impartial by giving enough options, right? We always have these biases, et cetera, unconscious, conscious, and that we do the best we can with them. So couldn't we do the best we could with saying, okay, this is about, all the options that are with respect to how to pay for college. How do people traditionally pay for college expenses? And it could be we pay equally, pay in portion to their income, blah, blah, blah. I don't, I think there is some chance of bias in that, but if we try not to, maybe that's the best we can achieve. And it's still worthwhile. That's something you would want to do, isn't it? If you were permitted to do that, would you?
Well, indeed. Well, and I think that, I would think that it would be a good thing to do if that was supporting party self-determination. So sometimes withholding those options would not be supporting party self-determination. It would be actually delimiting the scope of what the parties have on the table, because they're not able to come up with these suggestions themselves. But theoretically in Australia, it's not something that an impartial mediator would do. And I guess that may be where our systems are different. What we're saying is that that kind of way of thinking about things isn't really helpful to the parties.
Right. So could you give us a few more examples of things that are not permitted that you would like to see permitted?
So I guess the giving of options, suggestions, solutions, that really would be probably at the heart of what I would be seeing that that mediators would be able to do, but also advice. I guess the thing is that a contextual ethic is one. So William Simon wrote about a contextual ethic for lawyers, and Fletcher wrote about it in other contexts. That you really, it's quite a challenging thing, because it's the kind of idea that the context dictates what is required in terms of intervention. So the fundamental premise is that whatever I do as a mediator must be supporting party self-determination, and depending on who the parties are and what their needs are. And I think it would come down to advice and options and suggestions and proposals at the heart of it. But it would depend what the particular context for those parties needed. What do they need in order to achieve party self-determination? And if I can say at the end of a mediation that what I did as a mediator supported party self-determination, then I can ethically justify whatever I did.
Okay. Is there a bridge too far? Is there something that you could do that you would say, no, it's too far. I just can't go there?
Look, I think if those elements of that I described before, in terms of the self-determination, the informed consent, the professionalism and competence, and the respect for relationality, if all of those aspects of the contextual ethic that we're proposing were satisfied, I don't think that there is a bridge too far. But I do think that, and this is something that we were talking about just before we started the discussions today, of the importance of consensuality in terms of the parties agreeing to whatever they are a part of as a process. So if we are moving towards a more determinative process, if we're moving from the facilitative through advisory and we're thinking we're now getting, the boundaries, we're going to step too far, I think then what we need to do is then renegotiate with the parties what process we're in and what they're asking the mediator to do, and perhaps amend the agreement to mediate, or amend the agreement to mediate is what it would really require, that the parties are needing something different from the mediator at that point. And one of my colleagues from the Dispute Resolution Centre at Bond, John Wade, who some of you might know, he's now in Canada, wrote a lot previously about the last gap. And I think that is a big problem in mediation. It certainly has been for some of the mediations that I've been involved with. And it's funny that you mentioned college, because one mediation that I did this year, the parties, the last gap for them was which high school the teenage daughter would go to. Mm-hmm. And there were two different ideas from each of the parents. And no matter what Libby and I tried, there was no way that we could get them to find a middle ground. And it was that last gap. And what I would have loved is to say, what ended up happening is that we gave the parties the certificate that they needed to say that they'd taken genuine steps to resolve matters, and they went off to the family court and filed, and I don't know how many thousands of dollars they spent, but they would have had a decision made for them. What I would have loved perhaps is some kind of a chance to move to a med-arb, or a different kind of approach in the process, where we say, okay, we're not getting anywhere with this. Would you like Libby and me to now make a decision for you, and we'll tell you where on the basis of all the information that we have. Or we could call in a colleague, one of our panel from the Dispute Resolution Centre, and they could make a decision for you.
Before we came on, during the practice session, I read to you a question that I use when teaching ethics in the 40-hour course. And it's on self-determination. It says, the parties are at the end of a mediation and ask you to make a call on the last but critical issue. What do you do? Refuse on the grounds you said you would not make any decisions for the parties, make the call to avoid a breakdown of mediation. And I understand you're clearly in, I would love to be able to make that call if the parties want me to do that.
Yeah, if the parties agree. I mean, it's consensuality is the whole premise of the agreement to mediate is the central thing, isn't it, in terms of giving us authority to do whatever we do. So I think that there's potential in us thinking if we can renegotiate that, if that's what the parties want. And I guess there's a whole lot of safety mechanisms we need to have around that to ensure that it is indeed what both parties want. And again, things like informed consent, professionalism, relationality, all of those things come into the judgment about whether that would be a move that you would make. But I think it's preferable to think about it in those terms, that we're moving to a different iteration of the process now, because that's what the parties consent to and want and ostensibly need, rather than trying to adjust our approach to ethics to say that that's okay.
Okay. Let me read the second code, which is 99299929. So let's talk about self-determination, since that seems to be the overriding principle. And let's put aside domestic violence, because that's a real issue of whether people can exercise self-determination without an awful lot of skill that the normal mediator probably doesn't have. And let's also assume that people have competence, they're doing everything competently.
Okay.
Is there any limit to it? Is there any limit to what a party can self-determine? And the second question, and maybe it should have been the first question, is when should a mediator be getting the parties' agreement to something? I mean, I'll give you an example. I used to do, when you come to a difficult issue, I would say, well, that there are these options, blah, blah, blah. And sometimes the other party would say, why are you helping my spouse? Right? Which is always a problem. And so I turned to a protocol which sort of said, at the very beginning of the mediation, I would tell the people, I can tell you this. If you want to know, what your review attorney is likely to say, I can do that. I can tell you if you are doing something out of what people would say is the reasonable norm of what people do. And I can do that if you want me to do it, and go through a list of other things. And so I sort of get buy-in at the beginning. When do you get buy-in? How important is that? And is there no limit to that?
Well, I think in terms of the model that I practice currently, that's the model where I feel a bit stymied by our standards, that I'm not able to do that.
You can't do that.
Yeah.
Okay, so you can't ask them to say, do something outside of the norm. This is outside of the norm of what I'm permitted. You can't say, this is outside the norm of what I'm permitted. If you want me to do that, I will do it.
I would really like to be able to do that.
But you can't.
But I don't. Well, and I guess because I have to be respectful also of the model of practice of my co-mediator, who would be very uncomfortable doing that. So I might sort of have to go out on a limb and sort of be, practicing on my own, or find another co-mediator to, because my current co-mediator is very much a stickler for a sense of impartiality, and the limit that would be well beyond the limits of what she would think would be appropriate. Right. So, there have been times when I know that both she and I know what the law is. We could describe it to somebody, and we could actually give them a fairly quick explanation of what it means in their context. And we haven't done that. We've said instead, now would be a good time for you to go and get some independent legal advice.
Okay.
But that's sent them away, and it's brought them back. Things have deteriorated when we see them, when they come back. And I feel as though if we had just gone that extra step at the time when the moment was right, and if we were able to give that information and go beyond what impartiality expected of us, but still what was supportive of party self-determination in that moment, we might have been able to do some more good for that family and for those children. And instead, you know, the parties come back and they're warring even more, and the legal advice hasn't really helped. So that's a great professional frustration for me in that sense. So I would love to be able to say, okay, everybody, let's just, you know, let's renegotiate the agreement to mediate. And if you're happy with me being able to do these things, then I'm going to give you a whole range of sensible options that come from my experience as a mediator. I'd love to be able to do that.
Let me mention to everyone, if you have a question, you can raise your hand and we will turn on your mic. If you were not teaching in a law school,
Yeah.
would you do some of these things? I mean, you have a responsibility, I assume, because you're teaching at a law school, to be, I'll say, more ethical or comply with the standards probably more than if you were just out in a private practice where nobody is seeing you. And then would you be more likely to do things that you thought really are the things that need to be done?
Well, and that's what I hear my colleagues are doing. You know, the people who I speak to in practice are doing what is necessary to be done to support the parties. And they are justifying that. And it may be contrary to the national standards, the practice standards, but they can see that they're doing good. I guess the thing that worries me about that is who is regulating that, and what framework, what professional framework are people working in then? It just becomes an individual's own ethical framework. And we need that. We need something stronger for the profession as a whole to be able to subscribe to, that actually has meaning, that actually does sit well with what we're doing in reality and practice, and does come down to that fundamental point of, as mediators, how are we helping people? How are we helping them go away with a better situation than they arrived at our mediation rooms with? But I guess the thing that it's more than working in a law school. The thing that stymies me, in particular, my colleague Libby as well, is that we are accredited under the National Mediator Accreditation system, and we hold ourselves out as accredited mediators. So therefore, we have bought into those practice standards. And until they're amended, if we're practicing under that, you know, auspice, then we have to practice according to what the standards are.
What percentage of mediators in Australia are accredited?
So I asked this question of the chair of the Mediators Standards Board. The Mediators Standards Board is the board that administers the standards. And she told me, I think I'm right in saying this, that there are 4,000 accredited mediators, which isn't very many really, is it?
No.
No. I think that's right.
Yeah. We have an accreditation program, and our membership at its peak was a little over 500 members. And I think the most accredited members we ever had were about 104, 105. And it goes down every year because more people who are accredited retire, and fewer of the new members feel it's worthwhile, because you have to go through a lot of hoops to become one. And frankly, by the time you jump through those hoops, you've already established your practice. And a lot of them say, I don't need that anymore. I don't need the standard to build my practice. I don't need it to do anything. So it's been a problem for our association because we think it's worthwhile, but nobody really wants to do it anymore.
Yeah, we have one situation in Australia, in the Australian Capital Territory. One of the pieces of legislation says that in order to do court-referred mediations, a person must be accredited under the National Mediator Accreditation system. So the legislation is actually connecting in with this voluntary accreditation system and saying these are the mediators who can mediate under our court-based scheme. So that's an interesting development. That isn't the same in every state around Australia. And perhaps we need more of that to sort of encourage more people to be accredited. But yes, I think all of the things that you said apply. And a lot of lawyers won't be accredited under the National Mediator Accreditation system, because that system is premised on the facilitative model, and they don't buy into that model. They're not practicing that model, so they don't want to sort of, be accredited and held to it when it's not what they do.
Yeah. There's a lot of controversy here about former judges being mediators. A lot of people are, first of all, upset about they're getting an awful lot of the court-connected cases because they're judges. And so they feel it's unfair. I've never thought it's especially unfair. The one thing I do get concerned about is that they have tell their clients ahead of time, or the other, obviously the attorneys and the representing the parties know the person's a former judge and what he's going to do, but parties are informed ahead of time of what they're buying into. So they know, if I pick this person as a former judge, this person, if I want, is going to tell me exactly what happens in court. And to me, that's self-determination. They can do that if they want. And you would say that too.
Absolutely. Right? Yeah, I would agree.
And for example, I don't know very many transformative divorce mediators, but I would certainly want to know, if I were a client, what you are going to do as far as my divorce if you're a transformative person. Are you interested in getting me to a resolution of my divorce so I can go ahead with my life? So
yes, or are we just going to talk about unraveling the conflict and then rebuilding the relationship?
Exactly. So I want to know about all of these things, and if I tell the parties up front what I'm going to be doing, and they buy into it, I think anything is fair game, more or less, assuming again they're competent. We have just a couple of minutes, and let me talk about imbalance of power. And we talked about domestic violence. Clearly that's an imbalance of power that no one ever disputes. But I like the phrase more turned around, saying power imbalances, because power imbalance sounds like there's one monolithic thing that this is what it is. Whereas often, or I guess maybe always, there are power imbalances. Some have some strengths, some have other weaknesses. How can we, I personally don't worry about those. I don't, other than if they're in balance about information, et cetera, things that they can correct. How do you worry about imbalance, power imbalances, and what do you think your role is?
I would say that the element of the ethical paradigm that John and I are suggesting that's relevant here is the informed consent. So I think where there are power imbalances, then you may need to work harder with one party than another to ensure that they achieve that informed consent. They may need more direction or guidance as to how they come to informed consent. For example, they might need more referrals, they might need more time, they might need further explanation of things, that kind of thing. So I think informed consent and having a model for achieving informed consent is really critical, because I agree with you. There's not just one power imbalance ever. Each party will often have multiple sources of power available to them, and sometimes they're simply perceptions of power from the other side. They're not even real power, but they operate as real power as long as they are perceived as existing. So it's a very complex dynamic with power. I absolutely agree, and we can't just sort of think of it simplistically. It's got to be, it's part of our expertise is analysing the power in the room and understanding that and working appropriately with it.
See, I would view that what you have said as all sort of information, things that you would give to anyone trying to understand something, right? So for example, I want to go out and buy an air fryer, which I did, and my wife says, no, you can't have an air fryer. So I research these things to death. And I find out everything I possibly can about it, but I still reserve the decision to myself. You're not trying to influence the decision, are you? Or are you trying to provide enough information so they can make their self-determination?
The latter, yeah, the latter. So in the context, whatever that person needs, whatever level of information and support that they need to be able to make an informed decision, which is then part of party self-determination, I think it's ethical to support them in that way.
It's ethical under the standards as they exist. This is not something you want to be able to do. It's something you can do.
Well, no, under our standards, that would probably be a step too far.
It would be a step too far.
Yeah, going to that level of assistance or treating the parties differently in terms of supporting informed consent. That would be considered not impartial. So, but I would like to be able to do that.
Sounds like you have a lot of frustration in what you can do.
I still love mediating.
Right.
I just put it all the energy goes into the book writing. That's all.
Right. Okay. One last question. You're a professor at a law school.
Mm-hmm.
How many classes on mediation do you have there?
So at Bond, we're very fortunate. We've got the Dispute Resolution Centre. We run mediation training courses there. We've got 4 short courses that allow people to be accredited. But in our curriculum in the law school, we've got 6 dispute resolution subjects. Some are on offer only to JD students, and we only have one specifically for undergraduate students. But yeah, we're very fortunate at Bond simply because of its history of having the Dispute Resolution Centre and the amazing people that have been a part of that centre. We've got a great suite. It's not common to find law schools in Australia with so many dispute resolution electives on offer. And we also integrate dispute resolution into our core introductory law subjects as well. So I think that does make a difference in terms of our graduates and their approach to lawyering when they come out with a Bond law degree.
I'm sure it does. Well, you have been absolutely delightful, and you've been wonderful for getting up at 3 o'clock to do this for us. So I thank you very much. It was really a great hour.
It's been a pleasure. I'm so grateful, Carl, for the opportunity. So thank you, and all my best wishes to everyone in New Jersey.
Okay, take care. Go back to sleep.
Okay, I will.
Okay.
Good night, everyone.
Bye.
Bye.